and the earth, the sovereign of all creation. We bear witness that none has the right to be worshipped except you, the ever-living, the self-subsisting, and the supporter of all. By your grace, our Lord, we have gathered here today to celebrate the milestones that the Office of the Director of Public Prosecutions has attained this far. These achievements would not have been possible, our Lord, but for your pouring of your inspirations and blessings upon our Director of Public Prosecution, his team, staff, and our partners in the criminal justice system. To you, Allah, is all praise and thanks. We ask you, Allah, to continue guiding our Director of Public Prosecutions, his team and staff, in all their endeavors in fulfilling his vision. Our Lord, we ask you to grant him wisdom, courage, strength, and conviction as he continues to discharge his mandate. We ask you, Allah, for the good of this day and for the good of the days to follow. Our Lord, let not our hearts and the hearts of our leaders deviate after you have guided us onto the straight path, the path of whom you have bestowed your grace. Our Lord, burden us not with sickness, infections, and tribulations for which we have no ability to bear. We turn to you, admitting our helplessness and fear. We beg you, our Lord, to help us overcome this illness that has affected all humanity. And we ask you, Allah, to protect our health workers who are working tirelessly to nurse us back to health. Our Lord, grant us mercy, for you are the bestower of mercy, protection, and victory. Our Lord, accept our repentance. Our Lord, accept our supplications from your humble servants, and register us among your witnesses to the truth and to the faith of our forefather Ibrahim. We ask you for your blessings today and forever. We send salutations to your messengers. May the peace and blessings of Allah be upon our last messenger. May peace be upon you all. To you, Allah, is our submissions, praise, and thanks. Amen.
May we have the national anthems, please?
Ladies and gentlemen, welcome to the official event for the launch of the ODPP policy documents and case management system here at the Prosecution Training Institute. Let us begin with the Kenya National Anthem. And now, let us sing the East African Community Anthem.
Mungu twaomba uilinde Jumuiya Afrika Mashariki, tuwezeshe kuishi kwa amani, tutimize na malengo yetu. sote tuilinde, tuajibike, tuimarike. Umoja wetu ni nguzo yetu, idumu jumuiya yetu. Viwandani na hata mashambani, tufanye kazi sote kwa makini, tujitoe kwa hali na mali, tuijenge jumuiya bora. Jumuiya yetu sote tuilinde, tuajibike, tuimarike. Umoja wetu ni nguzo yetu, idumu jumuiya yetu.
Ladies and gentlemen,
Thank you very much. You may now take your seats. Our chief guest, the Honorable the Chief Justice of the Republic of Kenya, Honorable Justice David Maraga, our Cabinet Secretary, Minister of Interior and Coordination of National Government, the President of the Law Society of Kenya, the Inspector General of Police Service, the heads of independent commissions, chair of the IPOA present, members of the commissions present, and CEOs of the independent offices present here with us, members of the diplomatic corps, the ambassador of the EU delegation, Ambassador Modu, and distinguished invited guests, ladies and gentlemen, good morning. I'm pleased to be your program coordinator today, also known as MCA. I am Jacob Ondari, Deputy DPP in the office of the DPP. And on behalf of the DPP, and also on my own behalf, I wish to welcome you to this event and extend our warm welcome, although the weather is cold, to this event. And I thank you so much for taking time from your busy schedule to be here with us. This event is a culmination of months of work by the task force on the decision to charge, which was constituted by the DPP immediately after he took office 2 years ago. The task force constituted multi-agencies ranging from the National Police Service, the LSK, the IPOA, the DCI, among others. And with the stewardship of our SPP, we were able to complete this work, and today we are going to unveil the product of that task force. Our chief guest and distinguished invited guests, ladies and gentlemen, we have been supplied with the program. We shall endeavor to keep within the schedule, and on this, our request for your cooperation and strict observance of the schedules. This event will last 2 hours. We shall be having pre-recorded messages. We shall also be having speeches from invited guests who are amongst us here. And we shall have the launch of the decision to charge and case management document. Thereafter, we shall have a session for tree planting, and guests will be departing at their own pleasure. This event is very important to the office of the DPP because the decision to charge is the single most important decision of any prosecuting agency, and therefore this guideline comes in handy to assist and aid the prosecutors when making the decision to charge, as it has a life-changing effect on individuals. Therefore, it is an important event for the Office of the DPP and the criminal justice system in Kenya. The case management system, which will also be unveiled here today, will put to rest the hitherto elusive case management and record keeping of the prosecuting agency that we have been experiencing over the years. At this point in time, I will request that we play a video on the decision to charge, a synopsis of what the decision to charge is about, before we move to the next point. Thank you.
All public prosecution is vested in the DPP.
Initially, the Attorney General's was the home of prosecutions, and then it was a Deputy Director of Public Prosecutions as a department within the Attorney General's office. For that reason, they didn't have the necessary human resources to cover prosecutions, and so the function was delegated to police officers, and that's how we had police prosecutors. Police, of course, as an institution, are an independent investigative agency, and so the making of the decision to charge was not a standalone moment in time in the criminal process, but was a continuum, because the investigator continues to become the prosecutor. And so as the new constitution came in and created the independent office of the Director of Public Prosecutions, then there was a need to actually stop and say, what does it mean to be an independent office? What do we need to establish in terms of processes and systems and policies that would then reflect the independence of the office, as well as protect the mandate of the office.
The role of the prosecutor is to be a minister of justice, and number two is to be just and fair in making that decision to charge, and number three is to ensure that the fundamental human rights are safeguarded for all the parties that are involved when the decision to charge is being made.
When making the decision to charge, the prosecutor is guided by three tests. One, the evidential test; two, the public interest test; and three, the threshold test.
A prosecutor must be satisfied that there is prima facie evidence and that there is a reasonable prospect of obtaining a conviction against a particular individual. And this test is applied particularly in the early stages of an investigation in a case. You must be satisfied that there are certain circumstances that are met before you can make the decision to charge.
It is the single most important decision that a prosecutor makes. It is a life-altering decision, and it must be done in all fairness. It must be done impartially. It must be done in accordance and in adherence to legal provisions, what the law provides.
Then how do we get accountable? We get accountable by ensuring we have standard guidelines, standard procedures on how we exercise prosecutorial discretion. Needless to state, we only have one DPP, but that DPP cannot be in all the courts all the time. And we have 47 counties with prosecution officers. So we must have standard guidelines to guide all the prosecutors to ensure that prosecutorial discretion is not whimsical, it is not personalized, it does not depend on the size of the chancellor's foot. We have guidelines.
What the office had previously was immense experience, but with a pool of 60 prosecutors who were there at the time. But now with shooting up to 600 and now 900, there's need to give proper guidance to all the prosecutors who are handling everyday cases. And that is why the DPP tasked this particular task force to then develop guidelines that would go into near minute detail to guide the prosecutors on how to make the decision to charge.
From witnessing the process of intake of a case, to the arrest procedures of an accused person, to appearance in court, and different case management systems and procedures, the committee returned with new and reinforced ideas of how to improve an intake process in Kenya. And those ideas were used to refine the central intake practices that are incorporated in the decision to charge guidelines.
Some of the challenges that we face are the same. Crime is ever evolving, criminals respect no borders, technology is changing faster than the law. But our fundamental objectives to uphold justice and serve the public remain strong and true.
So I want to thank you very much. This is going to be a key step into rolling out ODPP's review of the whole processes and systems that we have in place. It cements the prosecutorial discretion in making the decision to charge. These guidelines therefore not only document but has anchored that discretion that prosecutors practice.
It directs the prosecutor on how to make the decision to charge. It will tell you this is what you're looking for and this is what is sufficient evidence with a reasonable prospect of conviction. What is the public interest? At any particular time in a country, you will know that it is in the public interest that everybody who is guilty where there's sufficient evidence must go to court. And therefore the DPP continually will give its vision through guidelines, policy documents, and instructions.
What the guidelines have done, under the decision to charge, there is a section that has listed out what is the minimum requirement of a file. And this is not subject to the nature of the offending, it is just because a file has been presented, it must have this. Where you create that, then you have incentivized the investigator to seek alternatives. That if this is something that was petty, then there's alternatives. You can divert the person. You can create some form of reconciliation between sisters who have fought. Unless for some reason it has elevated itself to the place of criminal offending, then can be resolved within the context of their family. So the guidelines require that there would be a certain minimum fees and there would be key evidence. A testimony of the person who has seen or witnessed, there's a testimony of the person who has arrested, there is some sort of, if there is documentary evidence or forensic evidence that it is present in the file at the time of making the decision to charge.
These guidelines give you a step-by-step guide on what you as a prosecutor are supposed to be looking out for in every single file that comes your way. And it tells you what alternatives are available. And in this way, it enables us as prosecutors across the country to have a certain standard in the decisions that we are making.
This is a significant milestone in terms of ODPP. For quite some time, we have been grappling with the issue of whether we can make standard decisions to charge. As you are aware, we make different decisions on a similar matter as prosecutors, and I believe once we sensitize the prosecutors well, then we are going to have standard way of doing things. And it's very critical for this office as we professionalize our services to the public.
I commend the task force and the implementation committee for your dedication to this process under the unwavering leadership of the director. Because of your hard work and commitment, it will move Kenya towards achieving a more fair and equitable charging process.
The launch of these guidelines today provides the public with an insight behind the prosecutorial curtain. These guidelines have been produced by a dedicated task force over many months.
Couldn't have made it without her. They came in and assisted us in the secretariat, they gave technical support, they gave us resources, and they have also undertaken now to help us in implementation. In fact, we already have an implementation program and guideline. They cooperated with us as if we were part of the ODPP, and we are very, very grateful.
Thank you very much. Chief guests, as you note from this video, this is just a synopsis of the decision to charge. The fuller text is in the docket, which you will be receiving. There is a small pack you'll be receiving, which will have the full text of the decision to charge guidelines. In this journey, we were working together with other partners, some from within, others from without. and because of the restrictions on travel, some of them are not able to be with us here today. And among them is the Lawyers Without Borders. Chief guest, I will request that you permit me to play a pre-recorded message from Ms. Jessica Rickman of the Lawyers Without Borders. Please.
My name is Jessica Reichman, and I am the Deputy Director of Lawyers Without Borders. I would like to start by thanking the DPP for the invitation to participate in this important event. For the past 2 years, Lawyers Without Borders has been working with the Office of the Director of Public Prosecutions to aid in the establishment of the Prosecutions Training Institute. Together, we have hosted numerous workshops and trainings in Nairobi on a wide variety of subjects. We have been honored to be a part of this historical undertaking and are inspired by the institute that has arisen from the efforts of ODPP and its many partners. One branch of this partnership between ODPP and Lawyers Without Borders focused on collaboration to improve case management systems. After conducting a baseline study of the manual case management and case tracking systems within the ODPP, LWOB and the ODPP launched a 3-point plan for a case management pilot program. This plan included both training and technical elements to streamline the process of case management. Last fall, Lawyers Without Borders and the ODPP hosted a 4-day workshop to discuss current issues in case management. Shortly thereafter, our organizations hosted our first training on prosecutorial case management. The training included interactive modules on challenges in case management, pretrial organization, negotiating a plea, and interacting with the unrepresented accused. With the information learned at last year's workshops and trainings, the ODPP and LWOB sought the expertise of a software development team and successfully created an end-to-end case management system. This software, designed specifically for the ODPP, will allow prosecutors to track documents and cases and to e-file documents with the judiciary. Today, the ODPP celebrates the implementation of this software into its existing case management infrastructure. This program, combined with specific case management trainings, will help ensure the ODPP is able to undertake criminal cases justly and expeditiously. Lawyers Without Borders is honored to have worked with the ODPP on this exciting case management initiative. From in-person trainings to Zoom calls, we are especially thankful for the willing and able partnership between our organizations. Lawyers Without Borders looks forward to our continued partnership and congratulates you on the launch of the case management pilot program.
Thank you very much for the message. Our chief guest amongst us is one of the agency CEO who investigates over 90% of the economic crimes and corruption cases. He's our valued partner because he generates the work that we do at the ODPP. And at this point, may I kindly invite the CEO, the Ethics and Anti-Corruption Commission, Mr. Twalib Barak, please.
Sorry. Our Chief Guest, Honorable David Maraga, Chief Justice and President of the Supreme Court of Kenya, Cabinet Secretary, Minister of Interior and Coordinating of National Government, Honorable Dr. Fred Matiang'i, the DPP, the IG, the European Ambassador to Kenya, and the President of the Law Society of Kenya, Head of Agencies. I would like to point Major General Fatma. You know, we were enlisted together in the military in 1984. So it's somebody I know her very well. Distinguished guests, ladies and gentlemen, this is a great day for us as EACC because it gives us a pleasure that we are here today to witness the launch of these guidelines on decision to charge, which to me is a very great step by the DPP. The launch is timely as it comes a month after the launching of the judicial electronic filing system in all courts. Some people are saying that COVID is forcing us to adapt to new technology very fast, and this is a confirmation of that. It confirms that the criminal justice system is on an active transformation and is committed to providing timely justice and quality dispute resolution services to the people of this country. On the war against corruption, we believe that in order to wage an effective and long-term sustainable war, it is critical that all actors of the criminal justice sector has to focus on the three main areas, that is strengthening institutional, legal, and policy framework to ensure effective administration of justice. We have a tendency in this country that we like to do a blame game, saying EACC is not working, DPP is not working, judiciary is not working. That is not a solution. The solution is to strengthen these institutions and see what is the outcome out of it. Harnessing and leveraging on ICT for an efficient and responsive justice sector. 20 years ago, you'd go to the immigration and queue for 3 hours to pay for application of passport. Today, it takes less than 10 minutes through an online system. So the way forward is that we have to harness the ICT, perpetuate impactful and strategies whose objective is to ensure retribution, deterrence, and restorative of justice. Many people in this country are suffering. Even us as a commission, the Master of Ceremony has talked of us being one of the clients of the DPP. Getting a witness every now and then to travel a long distance, that witness gets exhausted, he becomes hostile, and that partly contributes to the collapse of some of these corruption cases. So the ICT will enhance not only efficiency of timings, but convenience to other players in the judicial system. Firstly, the importance of strengthening institutional policies and procedures in an organization is paramount in instilling public confidence. The guidelines on decision to charge will act as one of the stop guide and reference point not only to the prosecutors, but also other stakeholders in the justice chain, such as investigators. When the prosecutors are in trouble, the investigators are also in trouble. When Haji loses a case, we don't feel happy because we feel that maybe we did something wrong. So when the DPP goes a notch high to launch this kind of system, as one of his clients, we feel very good. On our part, EACC has developed and reviewed its critical policies to ensure the highest level of effectiveness and accountability in order to foster public confidence. Just to mention a few, the EACC has developed the following policies and guidelines, that is Corruption Investigation Practitioner Guide, on what an investigator is supposed to do when he's handling a corruption case. For instance, a very small example, we don't allow one investigator to go and interview a suspect because the guy may come out and say, he was hostile to me because he demanded a bribe. How do you prove yourself innocent? So there are rules and regulations on Corruption Investigation Practice Guide. We have an alternative dispute resolution guideline whose objective is to bind the negotiation process within universal principle of utmost good faith, fairness, transparency, and accountability. Our work as a commission is not only to see the punitive aspect, we also focus on how to resolve these issues through alternative dispute resolution. And I know the DPP the other time last year, you launched and talked about the plea bargain. So policy on management and disposal of seized and confiscated assets. This is another document which provides the procedures for managing assets that come in our possession in the process of recovery of corruptly acquired public assets and unexplained wealth. I'm pleased to report that these policies and guidelines have bolstered the EACC programs and activities in the law enforcement. It has facilitated the Commission to record great milestones, especially in extinguishing the motive of corrupt conduct, which is to obtain a benefit For instance, in the last financial year, that is 2019-2020, we have averted possible loss of public assets, approximately 1.4 billion. This is so silent because Kenyans want to see people in court. But when you see somebody in court, the money has been eaten. Recovery becomes a very big task on that. We have recovered corruptly acquired assets worth 10.9 billion. That's about 11 billion. So with our budget of 3 billion, we can justify our gains in terms of the allocation of our budget allocation per year. Pursuing forfeiture of assets estimated to about 2.5 billion from public officials who own assets that are disproportionate to their non-legitimate income, or sometimes we refer it as unexplained wealth. And we have no doubt in mind that we are heading to the right direction. And as the Master of Ceremony has said, EACC stands to be the biggest client of the DPP on corruption cases. I know the guys behind there, they like talking of the war on EACC. So if we are handling 98% cases from EACC, I don't know how 2% will make somebody lose, even if it is a grading at the university, for you to get an E instead of a pass. So ICT infrastructure, ladies and gentlemen, that is the second area of focus for an effective justice system, which relates to the harnessing and leveraging of information and communication as a driver of change in the country. There's broad-based consensus that ICT has a potential to make significant contribution in the fight against corruption, and is not only against corruption. General security of the country becomes good when the ICT system is very much advanced. I went to Taiwan, and this is a country which, okay, it's not a country, it's part of China, but quite isolated. And therefore, for us as Africans, when we were moving around, I think the police got, who are these fellows? They never asked us a question. They just monitored us. When we entered into the hotel, they went to the reception. They took less than 10 minutes, IG, hatukushikwa suruali na kuvutwa juu. They took less than 2 minutes to know that we were there legally. They just went to the reception, they keyed in, and they keyed in their system, and they got all the details that these are Kenyans who have landed on this date, and they went away. So ICT is everything in security. And some of the possible areas in which ICT can help combat corruption, it is automation. Automation is everything. And on IG, I think, like traffic, our neighbors in Tanzania now, they have done the automation. The motorists, they are very much aware of all coding of offenses. When you're told you are speeding, they know it's called 001. So you take very less time with the policeman to do the charging, and you pay through ATMs, through automation. And that generally reduces the human interaction, and through the reduction of human interaction, generally it reduces the corruption. We are talking of reporting of crime by creating complaint channels that can lead to concrete action. We are talking of deterrence through dissemination of information where the public and the law enforcers become partners, but not enemies. So it is in this note that I'm confident that the ODPP case management system will enhance transparency by making prosecutorial process auditable and limiting of discretion of decision maker, any delay from receipt of inquiry file, making decision, preferring charges, and making the public online in terms of awareness of what is going on in the DPP office, if it is EACC, if it is judiciary. So EACC is also in the process of modernizing and automating its system, and we are working with the DPP to make sure that this system integrates with our system. And I'm pleased to report that our perspective of technical officers, they are already in partnership with the DPP personnel for the inception meeting that has taken place, and we are working towards integrating the two systems, which will make more cohesion and efficiency in the service for the people of this country. I believe that integrated case management system, DPP, will be a game changer for investigation, prosecution, adjudication of corruption cases, and also for the public to be at par with what we do. Because some of the things that the public condemn, especially our institutions, when they're talking of judiciary, they're talking of DPP, they're talking of the police, quite a number of these criticisms are based on ignorance. And you cannot blame the public. It is because we are not working with the public. And it is through automation that we'll be able to bring the public into this kind of participation. So in conclusion, I wish to reiterate that EACC is committed to working closely with the key stakeholders under the Council of Administrative of Justice and other agencies and forums. And I would like to also assure the CJ that we are with you and we will work with you. Where we find issues, we'll address them appropriately through your office. And where you think we need guidance, we are ready for any criticism and any sort of advice that can enhance the war against corruption. We remain focused on implementing our strategies on prevention of corruption, focusing on asset tracing, asset recovery, investigation on high-impact cases. We agree with the DPP that we should not believe in numbers. We should believe in quality cases. That is high-impact cases that will achieve a conviction. Lastly, we wish to thank the Director of Public Prosecution for the invitation of the launching of this program, because we feel that we are part of you. And rest assured, as a commission, we are supporting you, and we'll be working with you. Thank you very much, and God bless you all.
Thank you very much, CEO. I don't think I have anything useful to add. Those remarks were spot on. I'll now request, with your kind permission, that we play a pre-recorded message of one of our key partner who was not able to make it this way because of the travel restrictions. He's been with us from plea bargaining, the decision to charge, and generally has been a great partner of the office of the DPP since I joined the office. Please, may we have the message of the Ambassador for the United States of America, Ambassador Kyle McCarter, please.
Director of Public Prosecutions Haji and distinguished guests, Karabuni-san. I'm pleased to represent the United States at today's launch of a new case management system and 3 critical policy documents by the Office of the Director of Public Prosecutions. These are the Decision to Charge Guidelines, Plea Bargaining Guidelines, and Diversion Policy Guidelines. The United States has been a steadfast friend to ODPP over the years, championing its efforts to professionalize Kenya's prosecutorial service. Through our friendship we call USA Marafiki, our U.S. Department of Justice supported ODPP's efforts to deliver justice in Kenya transparently and with compassion. In November 2019, the United States supported a study tour by Director Haji and other prosecutors to Scotland and to the United States. There they observed the case intake and management processes and met with judges, prosecutors, and police officers. Tailored to the Kenyan experience, these exchanges were essential because the decision to charge is the most important decision a prosecutor can make. The lives of accused persons, victims, witnesses, and even loved ones and communities are impacted by these decisions. Critical to the success of ODPP's decision to charge guidelines is that all prosecutors and investigative officers understand their roles and how they can support one another. I encourage the ODPP to work collaboratively with EACC, DCI, and other investigative agencies to ensure every case is thoroughly investigated and reviewed and that sufficient evidence exists to prove the crimes. By collaborating, you'll reduce the number of cases improperly entering the system, increase convictions, protect limited judicial resources, and ensure a person's liberty is not unfairly jeopardized. I commend Director Haji on making case resolution a priority. The United States has supported the ODPP's use of plea negotiations to ensure effective administration of justice, which has solidified Kenya's status in East Africa as a leader in the use of plea agreements. With today's launch, another safeguard against corruption has been established. Prosecutors across Kenya are now positioned to apply the plea bargaining laws and the diversion policy consistently and uniformly. Congratulations again, Director Haji, and the entire ODPP for the development and issuance of the new guidelines and case management system. The United States stands with you to ensure justice for all Kenyans.
Thank you, Your Excellency. We thank you for the remarks. our distinguished guests, may we kindly have a short video on one of the tests on the decision to charge, that is the public interest, from Senior Counsel, Mr. Kyoko Kilukumi. Please.
Public interest is very different with what will interest the public. Public interest is what is in the common good, the commonwealth, the good of the country, the good of the people taken as a whole. And this is where, if you're making a decision to prosecute in these circumstances, it should be a uniform decision so that the public can, with a degree of predictability, say, if you do ABCD, the DPP will take the decision to prosecute you. Your decisions becomes predictable for the common good of the society. Remember, the prosecutors and prosecutorial discretion, they are fighting crime for the good of society. There are occasions, either for political reasons or for whatever reason, the public would want somebody to be prosecuted. The DPP must at all times withstand that pressure. You cannot take anybody to court simply to satisfy a crowd that is baying for blood. Those who are Christians will be familiar with the trial of Jesus. We don't want our DPP to be Pontius Pilate, asking, who do I release between these two men? He must be guided firstly and foremost by, do I have any evidence that this man has committed the crime? And it is not any evidence. It is not any scrap of evidence. Do I have evidence that reasonably, judging this as a trained lawyer, reasonably can result in a conviction? Absent evidence that can reasonably result in a conviction, that decision to prosecute should never be taken, even if the entire crowd is buying for blood. What is in public interest is very different from what interests the public.
I cannot agree more with us, distinguished guests. Is one of our partners in the Program for Legal Empowerment and Aid Delivery in Kenya, the PLEAD project. The Chief Justice, you are aware of the NCAJ and the work the PLEAD project is doing. With us, we have the ambassador for the EU delegation, who has been kind and gracious enough to grace this occasion. And at this point, I'll invite Ambassador Simon Madu to make his remarks, please.
Honourable Chief Justice, Honourable Cabinet Secretary, Director of Public Prosecution, Inspector General, CEO, Chairman, other distinguished guests, all protocols observed. I'm honoured to be part of what I believe is a very significant occasion we're witnessing today. Let me start by congratulating the DPP family, in particular the committee members who have developed the decision to charge report and guidelines, as well as the diversion policy and the plea bargaining guidelines. I must say I strongly believe that if these are used widely and effectively, these instruments have the potential to bring about a fundamental shift in the administration of justice in Kenya. Why? I think this is because they cut to the core of current thinking within the justice sector and beyond, both within Kenya and also beyond, about what is involved in seeing justice served. They should help to allow the justice sector to prioritise better and to focus on the issues that matter most for the rule of law and for Kenyan citizens, giving weight to the cases that matter most and less to those that matter less. And what we're looking to achieve, and what has been looked to be achieved here, is to ensure that prosecutors and other justice professionals resolve cases in an effective and speedy manner, in a way that reduces the backlog, but also in a way that does not always necessarily mean there needs to be a criminal trial. It's also about making sure that the process allows some leeway, predictable leeway, so that minors, the vulnerable, and petty offenders can avoid a criminal record and avoid also spending unnecessary time in custody. Now, the development of these instruments have been guided by the ODPP, but yes, it has also brought together multiple actors in the criminal justice sector to the table, and with them cross-disciplinary thinking. And this is a great example of what my friend Twalib described as cross-agency work for the benefit of all. Now, the European Union welcomes very much and supports fully the intent of the ODPP to achieve greater consistency in the manner in which such decisions are made, and we're proud to have supported the development of the policy documents, in particular those in relation to diversion and plea bargaining. Now, as the decision to charge report states, the single most important mandate of all prosecutors is deciding whether to charge and how. And the decision not to charge involves new thinking. And this is where the greatest potential lies for transformational change, including in adoption of diversion and plea bargaining as alternatives to prosecution and trial, which are regional and international best practice. They've been used successfully in many jurisdictions with many benefits, whilst remaining fully within the law. The legal avenues are clearly different, yet I think the ultimate destination is the same: the arrival at the serving of justice. Now, more work clearly lies ahead in bringing these three instruments to life. Let me just assure everybody of the EU's continued support as you adopt the new policy documents as your new normal. This support is part of our broader package of EU support through the PLEAD programme, delivered with the support of UNODC to the broader Kenyan justice system, and includes as well specific measures to help the courts continue their work during the COVID-19 crisis, many of which I'm certain will be adopted as more common practice as we exit, hopefully one day, the COVID-19 crisis. I think the policy documents launched here today form a critical element of our support to increase the ability of the judicial system to handle and determine criminal cases in a manner that is expeditious and compliant with the Bill of Rights. I want to just end with a very personal note. Yes, quite clearly the justice sector in Kenya faces some challenges, but I think Kenya can be rightly proud of having one of the few credible, performant judicial sectors in the region. This reflects well on Kenya's advanced status as a democracy, and we're keen to continue to walk this journey with you and support you wherever we can. Thank you very much.
Thank you very much, Ambassador, for the kind words. Distinguished guests, ladies and gentlemen, please may we have now the President of the Law Society of Kenya make his remarks.
Wananchi watukufu wa Kenya, majirani wetu, wageni watukufu kutoka Ulaya, Jaji Mkuu, mkurugenzi wa mashtaka ya umma, mkurugenzi wa upelelezi wa jinai kama yuko hapa, mkuu wa polisi, waziri wa ndani, na Jaji Mkuu, na wasalimu hamjambo. Hamjambo tena. Najua kuna wengi hamsikii ninachosema. Your Excellency, Ambassador Simon Modu, I was greeting the people of Kenya, our neighbors, and our visitors from abroad, as well as our distinguished guests. When I arrived here in the morning, I'd come with a big bound document, quite elaborate, so that I could critique what my learned friend, Mr. Nordin Haji, the Director of Public Prosecution, has done for the last 2 years. But this being a territory that is quite unfamiliar with me, the Honorable Director of Public Prosecution, together with the Inspector General of the Police, accosted me and told me, look, have you going not to serve any civil process or criminal process here? Tutaruhusu wewe kuserve sisi makaratasi yote. Twaliba said they're the biggest client of the Director of Public Prosecution. If Twalib and the Inspector General of the Police are the biggest clients, then my friend Twalib, as well as the Inspector General of the Police, we're the biggest referral center for the lawyers, because you give us the biggest number of clients. Often in this exercise, there will be an opportunity for us to criticize you, but there will also be an opportunity for us to praise you whenever you do a good job. And this is one opportunity for us, as the Law Society of Kenya, to praise the Office of the Director of Public Prosecution for the great milestone that you have undertaken to come up with guidelines, case management, in order to determine the decision to prosecute, in order to determine the progression of the cases you present in court. Once upon a time, a story will be told. We've sent a signal to the investigating officer in Garissa. We're yet to receive a response. Your Honor, I do not have the police file. These are tales that are no longer told in court nowadays, because with an elaborate system to enable the Director of Public Prosecution make an appropriate decision to charge, take charge of his case, we're able to progress in court and make good use of the criminal justice system to ensure that those who are brought before a court of law are given what, in the words of Justice Kuloba, is a square meal. And indeed, a square meal is what every suspect is entitled to. A square meal is what every victim is entitled to. No wonder, therefore, today you have a square meal. And the square meal often starts with you, Inspector General of Police, because you commence the investigations, often on your own or sometimes upon directions from the Director of Public Prosecution. There are times when the cases relate to economic crimes, when the square meal will start with my friend here, Twalib. The square meal will often land on your table, my friend Nurdin Haji. It is your responsibility to ensure that the square meal is well served when it lands before the table of my Lord, the Chief Justice. Because when the square meal lands on the table of my Lord, the Chief Justice, we will be there to eat the meal. We'll be there to determine whether there is sufficient salt. We'll be there to see if the meal is well cooked. It is for that reason, therefore, that the responsibility upon your shoulder is an enormous responsibility. Before the promulgation of the 2010 Constitution, the decision to charge was so nebulous that no one understood really what was happening. But with your office now currently anchored under the Constitution, with a clear framework on what you're supposed to do, we are delighted to say that you've taken the responsibility which many with such enormous powers will not want to take. There are institutions here which 5 years, 10 years, and many years to come have not put in place guidelines to enable them exercise their discretion. My learned friend and senior Kilukumi spoke about public interest and what public interest entails. He spoke elaborately on the reason as to why public interest should never be confused with that which entertains or interests the public. I will give you another analogy. He whosoever has to make a decision in the public interest is like one riding a wild horse. Because public interest, if equated to that which interests the public, is bound to confuse the decision maker. No wonder, therefore, for you to make a decision that is not whimsical, that is not erratic, that is not oppressive, it is incumbent that we have guidelines. May I take this opportunity to thank the Office of the Director of Public Prosecution, there are many players who took a fundamental role in ensuring that we have these guidelines. I will not have the opportunity of mentioning all of you because I had mentioned all of you in my 30-page speech, which has been confiscated by law enforcement officers. But be guaranteed that all of you, state and non-state actors, have played a fundamental role. As the Law Society, I'm proudly associated with this noble initiative that is being launched today. May I specifically mention my council member, Herin Kabita, who worked hand in hand with the Office of the Attorney General in coming up with these guidelines. May you flourish. My friend, the Director of Public Prosecution, yours is a difficult job. I don't envy you. But nonetheless, I know you are up to the task. And those who work with the Director of Public Prosecution, my learned friend and senior Dorcas Odwor, my colleagues Ondimu, my colleagues Natome, my colleagues Mutuku, please enable the Director of Public Prosecution perform his duty. We are here, we'll always be there, we'll ensure that the scales balance. For every popular prosecution, there will be an unpopular suspect. Often you will see me representing that unpopular suspect. Just understand that we're just performing our duty for the scales of justice to balance. God bless you. God bless the Office of the Director of Public Prosecution. Thank you so much.
Thank you very much, Mr. President. I believe the speech you had written can be published as a paper, which we can read. And thanks for the kind words. Ladies and gentlemen, with us invisible though, are over 1,000 people watching us and the proceedings herein. And among them is one of our former Attorney General, Professor Githu Muigai. And at this point, I'll be requesting that we play a short message from the former Attorney General, please. I think in the interest of time, we will skip that for now and move on. Once it comes on, we will be able to play. I'm sorry for that. This is technology. At this point in time, may I kindly invite the Inspector General of the National Police Service to make his remarks. Please.
Thank you. The Chief Guest, Honorable David Maranga, Chief Justice and President of the Supreme Court, Dr. Fred Matiang'i, Cabinet Secretary, Minister of Interior and Coordination of National Government, Nuruddin Aji, Director of Public Prosecution, Twalib Mbarak, CEO, EACC, Ambassador Simon Modu, European Union, Alice Odiek, Director, Witness Protection Agency, Anne Makori, Chairman, Independent Police Oversight Authority, and all other protocols observed. I would like to take just a short statement which I will read and written for me But before I do so, I have some few remarks to make. One is to take this opportunity and congratulate the director, ODPP, and all the team who are involved in this process of coming up with the guidelines of decision to charge and case management system. Indeed, the National Police Service is the main partner. It's the main partner of the DPP. All the work which comes to the desk of DPP mainly comes from the National Police Service and my colleague ESCC, and I know he knows that I'm the main stakeholder. I'm seeing a lot of progress during the time of Mr. Nuruddin Haji, bringing all the stakeholders in the criminal justice system and give us guidelines on the decisions to charge, which tells you a lot of milestone. Because the police, as we commence our investigations, these are guidelines which gives us the highlights and the hint, the direction we are supposed to progress, so that our cases, when they reach the DPP, they are already in line with what is expected to move forward to the judiciary. This is a multi-agency approach, and I'm seeing multi-agency growing in the system of criminal justice system, and this is the way to go. Once again, thanks a lot, Director DPP, for this initiative. And I think with this, we are joining our colleague, the Chief Justice, for what he did the other day. And I would like to promise I'm also on the pipeline in coming digitized. With those off the mark remarks, I have just few words to make from my speech, which I would read as follows. It's a pleasure to join the DPP and other stakeholders in the criminal justice system during the launch of the guidelines on decision to charge and case management system. I congratulate the DPP and this dedicated team for the great milestone achieved in developing the guidelines to charge and the case management system. National Police Service is committed to work with the Office of the Director of Public Prosecution. We have a good working relationship, and both government institutions are committed to serve Kenyans to get justice. National Police Service is also in the process of digitizing its records, which is in line with the digitization programs so far noted in the judiciary and now ODPP. We look forward to closer working relationship with the DPP and other stakeholders in the criminal justice system. And thank you, and may God bless you all. Asanteni sana.
Thank you very much, IGP. One thing the IGP did not tell you is that where we are now used to be his training ground for the senior staff, and through the interagency sharing of resources, he kindly supported us to have this as our training institute. And we thank him for that. Our distinguished guests, ladies and gentlemen, now may I invite the Secretary of Public Prosecution to make a few remarks, and thereafter invite the DPP to invite the distinguished guests present.
May I remove my mask? Good afternoon. I will adopt the protocol as was read out by the IG, and I will, on behalf of the DPP, welcome all of you here again. We are very grateful for the pleasure of your company this afternoon. Now, as a public prosecutor, I understand that most governments are divided into three: the legislature, the judiciary, and the executive. But there is one area that you find the interplay of the three arms of government, and that is in the criminal justice system. And the criminal justice system is important because it is supposed to keep us secure, and at the same time, it is supposed to enhance and protect our rights. The legislature makes laws in a very strict term. That's why you find some actions are prohibited and some punishments are mandatory. After they make the laws, the executive, that is the investigators and the prosecutors, are supposed to investigate and prosecute before the arbitrators, who are the judiciary. Then the ball goes back again to the executive, penal institution. The constant there is the prosecutor. The prosecutor plays a very big role as the gatekeeper to the judiciary. Now, how has this role been played before? I have some slides. From the old constitution, it is understood that the function of a prosecutor is very important. The prosecutor is supposed to make a decision whether or not to charge, to select the correct charge. They can reduce the charges, they can plead again, they can divert. How did they exercise this under the repealed constitution? We were under the Attorney General. The most important factor there is that the Attorney General was an office in the public service. The Attorney General was not independent. Secondly, there is no provision that the Attorney General was exercising state powers of prosecution. Third, there is no provision that in exercising those powers, the Attorney General was required to have regard to the public interest, the interest of the administration of justice, and to protect the integrity of the court. While at the Attorney General's office, the office of the DPP was a department. Next slide, please. We were a small department in the office of the Attorney General. That is how we were. And how many were we? 93 prosecution counsel, 123 support staff. We could only prosecute in the High Court and the Court of Appeal. Most prosecutions in the lower courts were being undertaken by police officers. They were doing this without any guidelines. They were doing this without any policy. You would just get a file and go to court. There was nothing to guide them. How then were we sure that they were acting in the public interest? How then were we sure that they were protecting the integrity of the criminal justice system? There was no way of doing that. In 2007, there was an attempt to come up with a policy, but the problem with 2007 is that nobody knew what the policy was. It was not publicized. The citizen did not know what was guiding the office of the Director of Public, not Director of Public Prosecutions then, but the Attorney General, who was the Director of Public Prosecutions, and the Deputy Director of Public Prosecutions, who was the head of that department. Then came the Constitution 2010. The Constitution 2010 provides that the Director of Public Prosecutions shall be an independent office and shall exercise the state powers of prosecutions. He shall have power to direct the IG to investigate, and in undertaking his functions, he will have regard to the public interest, the interest of the administration of justice, and also to protect the integrity of the court. The DPP cannot do this alone, as Mr. Kilukumi had said, so he does it through officers who are subordinate to him. To give life to Article 157 of the Constitution, Parliament kindly legislated the ODPP Act. The importance of the ODPP Act is that it defines prosecutions. And it says prosecution means a prosecution under the jurisdiction of the director, a proceeding respecting any offense, the prosecution or prospective prosecution which is under the jurisdiction of the director and related to such a prosecution or proceeding and includes extradition proceedings and any appeal, revision, or other proceeding related thereto. But it further provides that the Director of Public Prosecutions shall formulate and keep under review public prosecution policy. It also provides that the Director shall promote appropriate standards of practice by public prosecutors, assistant prosecutors, and any other person exercising prosecutorial authority. Pursuant to that, we formulated Prosecution Policy 2015. And this is where our journey begins. When the Director of Public Prosecutions took office, he found when we were running a program called All for Justice, and we went around with him visiting prisons, we found that out of the 50,000 people who were incarcerated, over 50% were remand prisoners, courtesy of prosecutors. Their cases are taken very long. We found that most of those people could not afford bail terms. Some of them were in there for very petty offenses. Most of them were not represented. The DPP asked me, how do you keep tab of the cases that go to court? I did not know how to answer. He again asked me, how do you people make decisions to prosecute? Because very petty cases are going through the system. Some cases ought not to be there at all. They're supposed to be diverted. In some cases, they're supposed to be home. They're not supposed to be in remand. I told him we did not have guidelines as such. He again asked me, how do you manage when many of the people in custody or who are going through the criminal justice process are not represented? I had no answer. Again, he asked me, how do you deal with cases where it is not in the interest of justice to prosecute? I did not have an answer. But I told him, we have a Prosecution Policy 2015. When we went through the Prosecution Policy 2015, we found that there was missing guidelines for making the decision to charge. It was not provided for. There wasn't anything to do with case flow or case management. There was no provision for a central intake of cases to ensure integrity and quality in cases. There was no provision for monitoring and evaluation. Immediately, the DPP constituted the task force that now is the product of these guidelines. And therefore, I want to congratulate the DPP and the office of the DPP, the team, for having thought of this and for having exercised the mandate that he has been given under the Constitution. But on this, it is also a culmination of the promise that the DPP gave to Parliament when he was being sworn in. He promised that he would ensure that there is quality, standardized, and efficient prosecution. And this is the result of that. I had told you before that we were a small department in the Office of the Attorney General. I'd like to show you the structure of the Office of the Director of Public Prosecutions today. We have the Director of Public Prosecutions, we have the Secretary, then we have 5 departments: the Offenses Against the Person, Economic Crimes, Central Facilitation, County Affairs, and the Prosecution Training Institute. Under them, we have divisions. Then we have 8 regional offices, and we are in the 47 counties, and we are in all the 127 court stations. We took over prosecutions from the police. Now we prosecute in all the courts in Kenya. Having taken over prosecution, we realized if we don't take over the charging process appropriately, we will still have a problem of petty cases. And therefore, we took over prosecutions and we took over the charging process. With us here today, we have our 4 deputy directors, Mr. Ondari, who was our MC, Mr. Mutuku, who is somewhere here, Ms. Emily Kamau, and Mr. Kimuyu. We also have with us our 8 regional heads. Please be upstanding. 9 regional heads. Kindly be upstanding. So under these people to date, we have 609 legal staff, out of which 252 are male and 355 are female. It is only in the office of the DPP that we have more ladies. We also have 381 non-legal staff, professionals. Out of them, we have 189 male and 192 female. We need a clap for that also. Finally, the last slide, please. The office of the, no, there's one last slide. The office of the DPP is represented in every part of Kenya, as we can see. All the 609 legal staff and the non-legal staff serve the office of the Director of Public Prosecutions. Prosecutions in Kenya is centralized and is hierarchical. So all of us are exercising the delegated powers of the Director of Public Prosecutions. What Mr. Kilukumi had said, how will the Director of Public Prosecutions know that somebody who is making the decision to charge in Marsabit, in Garissa, in Lamu, in Kisumu, is doing the correct thing? He cannot be everywhere. And therefore, it is very important that we have guidelines that direct this police, that direct the legal staff on how they do their work. Most of you would ask, how come it has taken very long, 2 years, for us to come up with these guidelines? And I have an answer. When the DPP came to the office, he asked me how we were managing the terms and conditions of service. Because the International Association of Public Prosecutors protocols require that the rights and the responsibilities of prosecutors include terms and conditions of service. Therefore, before we gave them responsibilities and duties, the DPP has made sure that the terms and conditions of service of people in the Office of the Director of Public Prosecutions is improved. It is not the best, but it is much better than that. Secondly, as we were coming up with the guidelines, most of you would ask, how are you going to make sure that people follow those guidelines? Again, the DPP has put in place an ICU, internal, internal compliance unit to deal with professional misconduct or excesses. At the same time, we have inspectors who will be looking at the operations of the ODPP and how we undertake our work. With those few remarks, I want to congratulate the office of the DPP. I want to congratulate us, the task force, and I want to congratulate everybody who was invited, those who did not make it, and those of you who managed to be with us. It is now my joy and privilege to introduce to you the DPP, Mr. Nudin Haji. Since he took up the mantle, Mr. Haji has steered an innovative course in the criminal justice system. Today is but an example of what he has done to make the system more responsive to the many needs of change in this sector. There is a need to bring the relevant laws in line with the Constitution and to provide for a just framework for justice. This includes transparency and accountability in answer to the public interest aspect of criminal justice system. We are grateful for his leadership in this area and look forward to greater improvements under his tutelage. Thank you very much and welcome, DPP.
The Honorable Chief Justice and President of the Supreme Court of Kenya, Honorable Justice David Maraga, and our chief guest today, Honorable CS Dr. Fred Matiang'i, Cabinet Secretary, Minister of Interior and Coordination of National Security, Mr. Hilary Mutyambai, Inspector General of the National Police Service, Mr. Twalib Mbarak, the CEO, Ethics and Anti-Corruption Commission, Major General Fatma Gaiti Ahmed, Assistant Chief of Defense Forces, Personnel and Logistics, KDF, representing the Chief of Defense Forces, Brigadier Daniel Omondi Odeny, Chief of Legal Services, Kenya Defense Forces, Madam Agnes Shikuku, Director of Administration, National Intelligence Service, my former boss and also mentor, that's Agnes Shikuku, Mr. Nelson Harvey, the President, Law Society of Kenya, Honorable Anne Amadi, Chief Registrar of the Judiciary, Honorable Judges and Magistrate, Ms. Anne Makori, Chairperson, Independent Police Oversight Authority, Ambassador Simon Modio, the European Union Ambassador, Mr. Ben Shamala, Country Director, International Justice Commission, Kenya, Ms. Jessica Reichman, Deputy Director, Lawyers Without Borders, all development partners, distinguished ladies and gentlemen, good morning. I have opted to keep my mask. Sorry? Yes, good afternoon, sorry. Good afternoon, yes. I've opted to keep my mask, Honorable Chief Justice, of course, as a measure, but also we are about to go to the Eid al-Adha, and usually before then, you're told you cannot shave. So if I remove the mask, my beard is all over. I cannot shave until after the Eid prayers, and I slaughter the goat, so excuse me. I take great pleasure in welcoming you all as we launch the guidelines on the decision to charge and our case management system. Thank you all for taking time to attend this launch today. It is always a privilege to congregate together with such faithful and dedicated stewards serving to create a more efficient and effective criminal justice system. Our gathering is testament to the values of cooperation, coordination, and collaboration that bind us together, and today renews, rekindles, and reaffirms this necessary bond. As Martin Luther King Jr. said, we are now faced with the fact that tomorrow is today. We are confronted with the fierce urgency of now. In this unfolding conundrum of life and history, there is such a thing as being too late. Procrastination is still the thief of time. Life often leaves us standing bare, naked, and dejected with a lost opportunity. As the Office of the Director of Public Prosecutions, we are taking advantage of every opportunity before us and embracing that fierce urgency of now in discharging our mandate for Kenyans. The ODPP is a critical link in the justice chain as the Constitution delegates immense authority to prosecutors. The reasoned exercise of prosecutorial discretion is essential to the fair, independent, and accountable administration of justice. The decision about whether to initiate charges, the charges to pursue, when to accept a negotiated plea, and what to advocate at sentencing are the most fundamental duties of prosecutors. We acknowledge that such authority must be accompanied by great responsibility. And in exercise of this authority, it is important that prosecutors follow processes and steps that ensure consistency, transparency, and accountability. When these processes are applied equally and fairly, the result is not only a more efficient and effective system, but also an increase in public confidence necessary in the administration of the criminal justice system. The decision to charge is the most significant decision a prosecutor makes in the handling of the criminal cases. The power to charge entails considerable discretion on the part of the prosecutor, and the decision must therefore be founded in law, serve the public interest, ingrain fair administration of justice, and avoid abuse of the legal processes.
Over the past year, we made it among our top priority to go around the country through our All for Justice initiative. I had the pleasure and privilege of sitting down with Kenyans to listen and learn and understand their concerns in relation to prosecutions and the justice system. The two common questions that the Mwananchi from Lamu to Homa Bay, in the community social halls to the correction facilities, asked were, how do you decide whom to charge, and how do you make the decision to charge? These frequently asked questions affirmed our belief that the promise of our criminal justice system depends on how we make the decision to charge, and it really was about understanding our mission as the ODPP, which is to provide impartial, effective, and efficient prosecution services to the public. Citizens seemed to know that being at the heart of the criminal justice system, the prosecutor must earn their trust and faith, and that any decision they make must strictly follow the law and also safeguard their collective interests. That's why today we leverage on our experiences and the lessons learned from prosecuting crimes. We have developed these guidelines on the decision to charge. The guidelines document the steps to ensure fairness, consistency, transparency, and accountability in the decision-making process, and that they are applied equally and fairly to bolster public confidence in the administration of justice. The key features of the guideline is the two-stage test, which comprises the evidential and public interest test. Under the evidential test, prosecutors will have to ascertain the reliability, credibility, admissibility, sufficiency, and the strength of rebuttal evidence with a realistic prospect of a conviction. Under the public interest test, prosecutors will consider the culpability of the suspect, the impact or harm to the community or victim, the suspect's age at the time of the offense, and whether prosecution is a proportionate response. It is important to note that while coming up with these guidelines, even as we benchmarked with the best practices from other jurisdictions, we made sure to customize them to our own unique situation in Kenya. In addition to these guidelines, we have also developed more policies on the alternative to prosecutions, which include plea bargaining guidelines, diversion guidelines, deferred prosecution guidelines. We have also formulated other guidelines on delegated prosecutions, practice directions on delegation of prosecutorial powers, guidelines for the administration and management of the prosecution fund, traffic rules and guidelines. I'm confident that these policies and guidelines will bring uniformity, consistency, and predictability in discharging our mandate and express our deep commitment to convictions and correctional phases. More importantly, it can also help us know where to focus as we seek to improve the criminal justice system by providing real-time qualitative and quantitative data. It will also enhance and enrich policy formulation. I urge all actors in the criminal justice system to embrace the use of information technology. It will create synergy and ensure transparency, accountability, and fairness in the delivery of services. Through our Prosecution Training Institute here, we are setting up an e-learning center to provide resources and conduct continuous joint trainings, both at an agency and interagency level, including sessions on the integrated case management system. Finally, I would like to extend my gratitude to the Chief Justice, Honorable David Maraga, and the Interior CS, Dr. Fred Matiang'i, and the Inspector General of Police, Mr. Hilary Mutiambai, and Twalib Mbarak from the EACC, our partners both in government and non-governmental organizations who have worked with us tirelessly in ensuring that we realize this great milestone. Your continued support and commitment is indeed appreciated. As mentioned earlier, ODPP is taking advantage of every opportunity before us and embracing that fierce urgency of now in discharging our mandate to Kenyans. It takes courage to push for change, and yes, we note that we will be challenged at every step, but it takes a steadfast spirit and fierceness beyond words
Because if not now, then when? And if not us, then who? Talking about change is easy, but doing it takes courage beyond bounds, and we at ODPP have committed ourselves to be a change catalyst for our beloved Kenya, despite the threats, either emanating from terrorism or corrupt individuals. So here is to my colleagues from the ODPP. Boundless courage in the face of adversity, doing what we see is right for the people of Kenya, and continuing fiercely to push forward, now towards ensuring a fair, independent, transparent, and just criminal system. As my dear friend Tomika would say, she's not here today, if not now, then when? If not you, then who? This is the fundamental question for all of us gathered here today. This morning, let us renew our commitment to increased cooperation, collaboration, and coordination. When we leverage on the dedication and expertise of everyone gathered here today, I know we will be able to achieve success. We at the Office of the Director of Public Prosecutions are optimistic about the future. We pledge to uphold our solemn obligation to see that justice is done to the Mwananchi, whom we are called upon to serve as ministers of justice. We assure you of our commitment to our clarion call, mashtaka yenye haki na usawa. And for each of our partners here today, it is an honor to work together, and I look forward to our continued work together and even greater accomplishments in serving Mwananchi. And before I conclude, I would want to mention a few names of individuals who have brought this to fruition. Charity Kagwe from the United Nations Office of, I think, Drugs and, Wamaitha from IJM, Tomika from the Department of Justice, she's not here, Shamini from Save the Elephant, Jennifer Bana from CPS. Probably you can just stand up if I mention your name, sorry. So I'll start again. Charity Kagwe from UNODC, Wamaitha from IJM, Shamini from Save the Elephant, she's not here, Jennifer Bana from the Crown Prosecution Services, the EU ambassador who has helped us, Lilian Arieko from LOB, Chooks, if he's here, from AGA. There's Herina Kabita from LSK. She participated with us. There's a team from the Executive Secretariat, the team from the PTI, the ICT team headed by Alex. I'll also want to mention Tito Ayera from NPS, National Police Service, who also participated. And finally, Mr. Patrick Obimo, who is the current commandant of the National Police Training Institute. And most sincerely, I would like to thank the Chief Justice for coming here today, but also the Cabinet Secretary, who ensured, despite a lot of resistance, that we got this college, and the IG for supporting that decision. Asanteni, God bless you all. Sorry, I think I'm the one who's supposed to now, sorry, I was going to leave it to Ondari, but I have the honor to now welcome Dr. Fred Matiang'i, the Honorable CS of Interior. Thank you, sir.
Mr. Justice David Maraga, the Honorable Chief Justice and President of the Supreme Court of Kenya, our brother and our friend, the Honorable Director of Public Prosecutions, Mr. Nuruddin Haji, the Inspector General of Police, the Chairperson of IPOA who's here, the Chief Executive Officer of EACC, Mr. Mbarak, the President of the Law Society of Kenya, the Honorable Chief Justice, I neither have a beard nor am I looking forward to any celebration soon. Unlike the DPP, I've just decided to keep my mask because of fear. Before I make my remarks, let me say the following. One, I am accompanied by a number of colleagues whom I would like to introduce. Our Assistant Minister in the Ministry of Interior, Honorable Ambassador Hussein Dado is here, and I have several colleagues from the Office of the President who are here. Secondly, DPP, I sincerely thank the Lord that I've had the opportunity to attend the first event in this wonderful institution that you've taken over now as the PTI. And on my own behalf and on behalf of my colleagues from the executive branch of government, I want to tell you sincerely that we will do whatever it takes to strengthen this institution and support you. And I look forward to more buildings, more capacity here, so that you can strengthen your institution. For obvious reasons and for some things I'm about to say, even we in the executive branch, much as sometimes we are doubted, we are very serious about supporting independent institutions. Because there is no way we are going to move our country to the next level if some of our independent institutions are not working effectively. We are the foremost beneficiaries, we, the security sector, from an effective and independent office of the Director of Public Prosecutions. And that is why, because we will have lesser challenges to deal with and lesser problems to deal with. So my brother, the Inspector General, and I, and all of us from the executive branch, wish you all the best as you develop this institution. And as I said again, we will do whatever it takes to support you as you move forward on this. So it is with great honor that I join you here today for what is a remarkable moment in the criminal justice system. We are gathered here to celebrate remarkable achievements of the Office of the Director of Public Prosecutions. But those achievements are themselves a noteworthy stride of the governance, justice, law, and order sector as a whole. They may belong to the ODPP, but they are inseparable from the rest of the sector. As a sector, we are increasingly witnessing the need for synergy and collaboration in the work that we do. The national and global transformation of businesses and communities, the expansion in trade, and the advancement in technology all speak to the need for us to work closely with each other and to continually improve the way we work in order to keep pace with the needs of law enforcement. As a country, we are guided by what the law says in everything we do. Among the key constitutional principles that come to mind are democratic governance, integrity, transparency, and accountability. The clarity of policy by independent officers within government, such as that of the Director of Public Prosecutions and the Inspector General of Police, is an important instrument for the realization of those invaluable national values. It is for this reason, therefore, that we are here today to celebrate the launch of the decision to charge, plea bargaining, and diversion guidelines of the ODPP case management system. The introduction and implementation of the decision to charge guidelines is an important safeguard against various challenges that are met in law enforcement. I take this opportunity to call on our National Police Service to keenly study these guidelines and system and offer all the support that the ODPP needs in the implementation of those key policies. The need for synergy in implementation of the guidelines and policies cannot be overemphasized, considering especially the high level of transparency that they bring to the law enforcement system. It is no secret that the majority of convicted prisoners are petty offenders who could have been dealt with in ways other than imprisonment. I strongly believe that the policy instruments we launch today will offer appropriate avenues for correction of such offenders in a manner that does not clog our justice system. And DPP, let me pause here and thank you very sincerely, because when we had several discussions that my sister Dorcas Odo referred to, the way we have worked together before, we actually have seen in the last a year or so an unprecedented reduction of the number of remandees. And this has come as a result of the collaboration that we work. In fact, in almost 2 years, we have reduced the number of remandees in our correctional service by over 16,000, which is, again, as a result of the guidelines that were given by both you and the judiciary. And I sincerely thank the Honorable Chief Justice for the support that we have gotten, because our correctional services capacity is actually not beyond 30,000. And when we were holding 52 or 53,000 people, we were already 20,000 more than our capacity could take. These numbers have come down significantly. And I can promise the country that if we stay on this trajectory, together with the things that we are doing here today, we are headed to a point where we probably will have just the numbers that we need to have in our correctional institutions, as it were. It is no secret that the majority, as I said, of the people we have in our institutions are petty offenders. It has come to a point where it is actually unreasonable what we do ourselves in the systems. We're working on the math with you, DPP and Dorcas, and finding out that to feed someone in the remand will cost us thousands of shillings, and this is a traffic offender whose fine under the law is 600 shillings. By the time the matter is hard determined and they pay the fine of 600 shillings, we have spent 20, 30,000 shillings. It's completely unreasonable. It just doesn't make sense at all. So I'm really grateful that this effort is leading to the direction we are going. It is therefore important for us to enhance the participation of victims and perpetrators of crime in reconciliation and restitution. This will not only reduce the backlog within our courts and lead to speedy case resolutions, but also reduce the numbers of second-time offenders. It is equally important to note that the implementation of the case management system is a significant move towards efficiency, accountability, and data-driven performance. It is my hope that this system will provide your office with detailed, objective data on crime and prosecution trends, prosecutor workload, performance, and resource allocation. This will enable the entire sector to formulate and implement the correct approaches to the discharge of justice. At this juncture, I wish to thank the judiciary for the launch of the e-filing system. The integration of the e-filing system with all other digital platforms, including the one we launched today, is a true mark towards a more cohesive and efficient criminal justice system. As I close, I wish to reiterate that the work of the ODPP, the judiciary, investigative agencies, and correctional authorities is inextricably linked. This means that gaps in the service delivery of one institution could very well negate gains made in another. Thus, I'm glad to see all of us in the sector working towards closing these gaps and building synergy in the delivery of justice. It is my hope that all the players in the criminal justice sector will strive to familiarize and embrace these worthy developments for the betterment of justice delivery to the mwananchi. Let us remember that a chain is only as strong as its weakest link. I congratulate you, DPP, and your wonderful, strong, dynamic team. I pledge my support and that of the Ministry of Interior and Coordination of National Government and all the stakeholders within our ministry. And I wish you all the best as you move forward. May God bless you.
It is now my singular honor and pleasure to invite my Lord, the Chief Justice for the Republic of Kenya.
Switched it off. Awesome. Is it on or off?
No, it's on.
Okay, okay. Thank you very much. Please sit down. Before I forget, I want to observe that Doc has told you about the gender balance in the ODPP. They have borrowed that from the judiciary. The judiciary has 51% females and 49% male. The Cabinet Secretary, Minister of Interior and National Coordination, the Director of Public Prosecutions, Mr. Nuruddin Achi, Inspector General of Police, Mr. Mutiambai, the President of the Law Society of Kenya, Mr. Harvey, Ambassador Modu, Your Excellency, our stakeholders and development partners, all protocols observed, ladies and gentlemen, good afternoon. It gives me great pleasure to join all of you here today as we launch two very important instruments in the administration of justice that have been prepared and developed by the Office of the Director of Prosecutions. These are the electronic case management system and the ODPP decision to charge guidelines. Nearly a month ago, on the 1st of July, the judiciary launched the e-filing system for all courts in Nairobi region, a significant milestone in the administration of justice in this country. We started from Nairobi, and in a short while, we hope to roll the system throughout the country. These two digital systems complement each other and will significantly enhance service delivery for the Kenyan people. As justice sector agencies, we are under an obligation to re-engineer our procedures and processes in order to serve the Kenyan people better. We demonstrate our steadfast commitment to our constitutional duties, less by mere muscular projection of power. The Constitution vests in us, but more by the quality of services we offer to the public and the fairness we exhibit in the exercise of that power. Our continuous review and upgrade of our service culture, practices, and instruments, such as the ones the ODPP is launching today, help greatly in this effort. The launch of the judiciary e-filing system this month, and of the ODPP electronic case management today is a powerful signal that the justice sector is getting into the digital age. It heralds a new and promising era of limiting human factor and the intervention, and its attendant errors of inefficiency and corruption in the administrative and decision-making processes. Or other factors in the justice sector, from the bar to the prisons to probation to police to Ministry of Lands and others, need to embrace and generously invest in technological processes, for the future is digital. Digitization is going to be the new normal in the administration of justice, and a rapid culture change and mental shift is imperative. The ODPP case management system enables the prosecutors to move and dispense cases through document tracking, case tracking, and e-filing. In this regard, I'm happy to note that two systems at the judiciary and ODPP have been successfully integrated, thus enabling the prosecution system to seamlessly access the use of the judiciary's e-filing system. As somebody has mentioned here this morning, in the past and it continued for very many years, you could have suspects brought to court and kept in the court cells for literally the whole day before the police file arrives in the judiciary. And you know the police file is just a charge sheet. With this system and the integration of the e-filing system of the ODPP, I trust that we are going to have those electronic documents transmitted to us even before the suspects are brought to court. The launch of the electronic case management system is a watershed moment in the criminal justice system. It promises to eliminate long outstanding problems that characterize the justice system, including missing files, delay, and general lack of accountability and transparency. While the digitization of the case management process does not solve all the challenges that face the prosecution and the criminal justice subsector as a whole, it is an important beginning. First, the technology addresses administrative inefficiencies and a lack of transparency in the case management process. Ease access and the retrieval of information will facilitate effective decision-making in the process of prosecution and thus enhance the quality and the value of critical decisions required in the course of their work. Secondly, as the old adage goes, justice must not only be done, but also be seen to be done. With the implementation of this system, members of the public, the accused, and other persons who interact with the public prosecution's service can and should have a more reliable and trusted channel of getting information regarding the status and the progress of their cases that are being handled by the prosecution. Thirdly, and most importantly, the administration of justice is a chain or a wheel with the different institutions and agencies, each performing a distinct but mutually reinforcing role. The digital platform the digital platforms lend themselves more easily to the collaboration and cooperation in service delivery than manual systems. The ODPP's electronic case management system was developed in close collaboration with the judiciary's technical team in the Directorate of ICT. The two systems are integrated, and this reflects the spirit of cooperation that should define relations between institutions in the entire justice sector. Indeed, the systems developed by the judiciary and the ODPP have a great potential to streamline communication between different agencies in the criminal justice sector. I appreciate that we are diverse institutions and the justice sector with the distinct respective mandates. However, the Constitution calls upon us to embrace cooperation and collaboration in the execution of our mandates, especially where there is mutual benefit in the pursuit of such a cooperation. There is no doubt that information sharing in a timely and efficient manner will enhance our individual and overall efficiency in the administration of justice. One such area, for instance, is the verification of documents submitted as security for those standing surety in the bail and bond applications. I want to pause here and state that we have met serious challenges. Accused persons are released on forged documents, forged title deeds. And we realized one instance in Eldoret where we had very many of those. We have also challenges with the verification of court orders. Sometimes the prison authorities hold suspects who have been released by the court for long periods because they are not sure of the authenticity of the court orders that they have been served with. With the e-filing system, with technology and integrated systems, we are going to have, those kind of challenges will be a thing of the past. The National Council on Administration of Justice, under the auspices of the National Committee on Criminal Justice Reforms, is working on a seamless integration between the court registries and the Lands Office in order to enhance the speedy processing of bail applications. I have directed that this effort should, as far as possible, be expanded to include the possible integration and the sharing of information required across the entire justice chain. I say this cognizant of the fact that different institutions are at different levels of leveraging the technology in their delivery of services. However, I strongly believe that, that developments such as the launch of the ODPP system and the judiciary one earlier present us with an opportunity to reflect on how to digitize our processes. Thomson Reuters, a company that works to assist courts and other government agencies in technology, harnessing for the delivery of their services, are this to say, and I quote, "We see increasing demands on people. Tomorrow's judges and their colleagues in the administration of justice will need a new approach to strategy, more empowered decision-making in the new digital world, and most of all, the adaptability and agility to lead a court system that keeps pace with rapidly changing demands of society," end of quote. This inevitably calls for a commitment in terms of resource, that is human and financial, and the effort to invest in technology. I call upon all to embrace these changes in order to remain relevant in the performance of our mandate and the overall and collective efficiency. Ladies and gentlemen, I have talked at length about the technology because, as I said earlier, the future of justice is digital. But I'm aware that we are also launching the ODPP's decision to charge guidelines, which are intended to guide the prosecution in decision-making with regard to the filing of criminal cases. I want to laud the ODPP for developing these guidelines. Article 157.10 of the Constitution requires the Office of the Director of Public Prosecution to exercise the power and decision to commence prosecutions independently without any influence or authorization. Further, Article 157.11 requires the ODPP to have regard to public interest and the interests in the administration of justice. These have already been alluded to by the past speakers, that the decision to charge must also be informed by public interest. These provisions seek to ensure that prosecutorial power is not only exercised independently, but is also exercised in a manner that promotes constitutionalism and the rule of law. This is an important step that is meant to add legitimacy to the use of prosecution powers in the country. Some of the immediate gains in the institutionalization of the decision to charge guidelines is the bringing to an end of arbitrary use of prosecution powers and the standardization and therefore legitimization of the prosecution function. The guidelines provide a basis and a gauge against which the legitimacy of decision taken can be measured. We must always remember that constitutional power is constrained power, which must be exercised fairly and judiciously, and certainly not in a selective, imperious, or a capricious manner. It is not lost on me that the theme of today's function is independence, transparency, and fairness in the prosecution service, and the guidelines being launched today directly relate to the chosen theme for today. I therefore take this opportunity to congratulate the ODPP for this step and request the officers in charge to make active reference and use of the guidelines in their work so that the prosecution decisions are not only transparent but consistent. The National Council on Administration of Justice, which I chair, and whose membership is represented here today in great numbers, is the embodiment of the cooperation that exists in the justice sector. I therefore take this opportunity to remind all of us of the need to continue seeking joint solutions to the challenges that collectively affect the administration of justice. In this regard, I urge all agencies in the criminal justice sector to seek ways of integrating with the judiciary's e-filing system in order to ensure all-round efficiency in the management of criminal matters. I recently extended the term of the National Committee for Criminal Justice Reforms for a further period of 2 years. The committee brings together all actors in the criminal justice, and I believe that together with the Council, we can put effort and work towards strengthening the criminal justice by jointly undertaking initiatives similar to the initiatives that we are launching here today. Ladies and gentlemen, in a nutshell and in conclusion, I want to say that Kenya is a constitutional democracy with a written constitution that has been built as one of the most progressive constitutions in the world. It has an elaborate Bill of Rights and entrenches the doctrine of separation of powers. In our Constitution, besides the traditional three arms of government, the Constitution has also established independent commissions and independent offices. Independent commissions include the Kenya Police Service, and among the independent offices is the Office of the Director of Public Prosecutions. These offices are established to serve the Kenyans better. Each of these offices plays a very key role, and it is important that they always remember that. In the present times, we are in an era of complicated crimes. We are in an era of an enlightened populace, which is quite litigious. It demands accountability. It demands transparency. We are in a society that requires to develop and to serve the Kenyans better and do what we are required to do to enable the country prosper. Those of us in the justice system have no choice but to continue evaluating the way we are operating and improve every time. To succeed in dealing with crime, the justice agencies have got to be ahead of the criminals. Otherwise, we will completely fail in what we are doing. To do that, we need to harness technology in the use of and in our operations. But let me tell you one other thing, that criminals don't want an efficient system. Mr. Haji, you are going to get opposition in some of the initiatives, IT initiatives that you are launching. We have faced them in the judiciary. We have faced them in the judiciary. You know, the chief registrar of the judiciary came up with the e-payment system and directed that all revenue collection be made electronically. She has met a lot of opposition. You find in a court, there are suspects who have come, they have been fined, they are supposed to pay their fines electronically, and they are told, look, the systems are down. The M-Pesa system is not working today. But the M-Pesa kiosk outside the court is working efficiently. So the suspects are directed there to cash the money they have in their phones and pay cash to court. And as a result of that, we have had tremendous loss of revenue. And I had to direct that anybody accepting cash in the judiciary, I would first of all we would just, first of all, dismiss before we even entertain their cases. And that has tremendously reduced the cash collection in the judiciary. So, Mr. Haji, I want to congratulate you for these initiatives and urge you to use technology and serve the people of Kenya. If we are to make Kenya prosper as an economic hub, if we are to serve the Kenyan people by enabling them to enjoy their fundamental rights, the agencies in the justice sector must have processes that make it extremely painful to commit offenses. We must have systems that make it extremely expensive to commit some of the offenses. I saw, was it yesterday or a few days ago? No, I think it is yesterday. The president said that those flouting COVID rules, the bar owners who opened their bars during this COVID season, will have their licenses withdrawn and withdrawn forever. Those are the kind of measures which will be so painful, so expensive, that we will all abide by the rule of law. I want to call upon all the justice sectors as agencies here present that is what the Kenyan people demand of us, to be efficient and make commission of crime painful and very expensive, so that we can all live under the rule of law. Once again, congratulations, Mr. Haji, for this innovation, and I want to assure you that the judiciary will be there to cooperate with you, to work with you, to offer the Kenyan people the service they require. May God bless you all.
Thank you very much, our chief guest, the Honorable CJ. Distinguished participants, you'll agree with me that the last three speakers have given important remarks in the realization of the independence, the transparency and accountability of the system and the office of the DPP. I will request that we put our hands together and appreciate all of them together. Thank you very much for this. At this point in time, in the interest of time, we will now demonstrate the case management system, and I'll request Siada and company there to please come online and explain to us how the system works very briefly, and also how we can, as prosecutors, file a case from our chambers. Please.
Thank you, Mr. Ondari. Good afternoon, ladies and gentlemen. My name is Siada. I'm from ICT ODPP. Much has been said about the case management system, which we call Uadilifu Case Management at the ODPP. The case management system has 3 modules, and the first one is called document tracking, which is, the name explains, tracking of the documents, movements of the documents within the office up to the time when it comes to the e-filing system. And the second module is the e-filing. That is where we file the charge sheets, the witness informations, and we'll do a live demo for that. It's just an introduction I'm doing. And the last is case tracking. That is now after the prosecutors have already filed the case and it's the judiciary side. Any updates, hearing dates, anything that happens to the case, we get updated over our own system. So that has many advantages, as the DPP has explained earlier. Sometimes you have issues of files being misplaced accidentally. Sometimes a file is scanned to a wrong case and stuff like that. So the document tracking has document security measures where we use a QR scanner to determine whether a file is scanned to the right case by comparing the QR scan with the reference number. So let us just jump into the system, log in, and see what it can do. It can do a lot of things, but at the moment we'll just do sampling for the sake of time. So welcome to our Delivery Case Management. So these are the modules I was talking about earlier. So we're starting with the document tracking. This is where we receive the files and record, and then we scan and index them, screen them, and then this is where the document security comes in, the file allocation. This is the point where a file is allocated to a certain prosecutor, and this can be done anywhere in the country. It's not only in Nairobi. So I've already logged in. Let's say these are the files that have already been allocated. And I come here, accept the file. This is where the QR scanner comes in. It was file number 6. So we come here. File has already been scanned to the system and successfully accepted. And now it goes to my accepted files, where it goes through the document processing process. So I wanted to demonstrate the part of the security. If, let's say, I was to scan the wrong file here, if I'm to scan the wrong file here, as you can see, it's giving me an error. You have entered an invalid QR code. So this is very important for us so that the file misplacement and the file is missing and all the other issues that, excuses that have been there before will not be here anymore. So we're really proud of it. So we are going to the second, which is the e-filing. So here is an explanation of the e-filing process along with the case tracking. So once a prosecutor logs in, this is the page that comes up where we capture the general details of the case, like the case date, the court, is it in what kind of division, the investigative agencies, and the details of the investigating officer. So, and like the OB number and the OB date. So once we are done with that, we add the investigative agency. Then we go to the next one, which is parties information. That is mostly the accused. So we enter the details of the accused, like the names, the email addresses, and nationality, party levels, whether it's using ID number or passport, the date, and physical addresses. So we add the party, and then we go next to victim information, where we also capture the details of the victim, as you can see on the screen. So like the ID number, and whether it's male or female, the date, and citizenship. Once we're done with that, we add the victim. Then we go to charge details. We did not capture the witness because the witness information is captured at the disclosure point, which is not at this point. So that's why we are going directly to the charge details. So we come to after we capture the accused, and then we enter the reasons for the charge. Like in this case, an example is committing robbery contrary to Section 295 of the Penal Code. And then we also enter the particulars of the case, and we create a charge sheet. After that, we upload the charge sheet, which has already been scanned to the system, and it goes to judiciary. We wait for a reply. There it is, the case has been created. Now we go to the case tracking. And then hearing date is set. We select the court numbers, the magistrate judge name, and then location of the court. Is the accused person in attendance? Who is representing the accused person? And the prosecutors who will be dealing with it. It can be more than one, doesn't have to be only one. Any other interested parties are also captured here. And this is now where we take the plea, and then we enter the details of that. If you want, you can enter case summaries, but right now we don't have. And court case has been created. So, so as you can see, we already managed to integrate with judiciary, and we are in the process of integrating with IPOA and the SEC and also other investigative agencies in the future. And as we already tackled the security part, the other part that we are facing at the moment is during this COVID era, where contact-to-contact person is highly discouraged. You see where the ODPP is coming in to make sure that the investigative officers and the prosecutors and the officers of the judiciary don't have to meet in person to give justice to Kenya. So to us, this is a big milestone, which we are highly grateful for, and we're also happy that we're able to serve Kenya in this manner. So thank you so much, ladies and gentlemen, for giving us your time to listen to us and also watching this live demo with us. We are grateful, and that is the much I can say about case management at the moment. Thank you.
Thank you very much, Siada. As you have seen, this system is seamless, and the case has been created in the judiciary. It's only now what we need to do is to appear for a plea. I don't know which date you've taken, so that we can appear for the plea. Ladies and gentlemen, the time we've been waiting for has come. The launch of the case management and the policy documents, the unveiling will be done by the chief guest. And as you have demonstrated here on the filing of the case, everything is digital. This time around, we are also going to digitally launch this document. Chief guest, Honorable CJ, on your right hand is a launch pad. You'll press the arrow, the green arrow. Sorry. Where are the dummies? Do we have the dummies? Yeah. I think the Honorable CJ, we will now request you kindly launch the document. You only need to press. We may stand up. This is the moment you have been waiting for. You want to use this? Where is this? We need to sanitize this. Please get us the sanitizer, please.
Let me stand here.
You only need to press the green button with an arrow pointing to the right. And then we have the digital launch of the document.
It's okay.
Now, this is the moment. I'll count from 5, going down, and at 1, the Chief Justice will launch the guidelines and the case management. And we'll make that noise when you are happy that something nice has happened. 5, 4, 3, 2, 1.
Ladies and gentlemen, now we officially launch the Decision to Charge Guidelines and the Digital Case Management System.
I've not seen you. Thank you. Thanks for coming. You never know who is here. Thank you. Thank you very much, Chief Guest and distinguished guests. The press wants to take a few snaps for the papers tomorrow.
The evidential test is concerned with sufficiency of evidence. And what we mean by sufficiency of evidence is that there is sufficient evidence to establish all the essential ingredients of the offense for which the accused person is charged. There are about 6 principles with regard to the evidential test. The first one is availability of the evidence. Is the evidence available? Do we have it such that we can now submit it to court? Secondly, is it admissible evidence? And here we are talking of things like, is it acceptable in accordance with the Evidence Act in court? Is it acceptable? Will it be admitted in evidence, and will now the court rely on it? And then the third issue is it credible? If it is a witness.
The Office of the Director of Public Prosecution, Uadilifu Case Management System. Sasa, hello, my name is Awadi from the Office of the Director of Public Prosecution. The Office of the Director of Public Prosecution, ODPP, recognized the need to automate the process of case management to not only increase efficiency and provide timely status reports, but to also enhance access to the criminal justice system. The ODPP has therefore developed an end-to-end case management system. Case management is the skills and processes used by prosecutors to move and dispense cases. It includes the receipt of files and correspondence from investigative agencies, the decision to charge, which involves the guide of both the evidential and public interest tests, plea negotiations, bargaining and diversion, pre-trial sessions, trial process timekeeping, and organization skills. The newly automated case management system will involve the use of integrated menus developed for, among other
Thank you. Please
allocating
take your
cases
seats.
and managing,
Take your seats for the
serving,
final
and preserving
announcements
official
and
documents.
closing prayers. We have from here, ladies and gentlemen, as the guests leave, we will have also the ceremony of planting a few trees at my right. And thereafter, guests are requested to pass by the tent here. We have some snacks. And because of the public health guidelines, we cannot have a buffet meal for you, but you can carry something at least to chew on your way out. We thank you. Let's have Emily Kamau for a vote of thanks. Emily, Madam Emily, please. And then Beatrice will pray for us as we have the meal, and also for Johnny Masses, and also for the ODPP.
Good afternoon, everybody. Honorable Chief Justice, Honorable CS Interior, Fred Matiang'i, all protocols observed, ladies and gentlemen, on behalf of the DPP and the Office of the Director of Public Prosecutions, and on my own behalf, it's my privilege to have been asked to extend a vote of thanks on this auspicious occasion. First of all, we thank you for availing yourself to be here despite your very busy schedules. It surely demonstrates how committed you are in assisting us to achieve our mandate. Today's launch of the decision to charge guidelines and the case management system demonstrate what is possible when there is concerted effort towards achieving this common goal. You have all, in one way or another, enabled us in this work towards this achievement. The significance of the decision to charge guidelines demonstrates a shift from the old ways of decision making. We thank the Chief Justice for steering the NCAJ into the digital era through support of the virtual hearings, the operationalization of the e-filing system, especially in this COVID era, and the integration of the case management system between the judiciary and the ODPP, which will create an end-to-end case management system, the first of its kind in Kenya. We have a deep sense of appreciation to the task force, to the members of the task force who worked tirelessly to ensure that the guidelines were formulated and launched in time. Further, we thank the UNODC for your support on the decision to charge guidelines. Your support was invaluable in ensuring that the guidelines were developed in a conducive environment. To GIZ for your continued support, specifically the support given towards the development of a forensic component in the case management system, at the development of the e-learning tools. Asante to USA Marafiki through the US DOJ for printing of the decision to charge guidelines and any other support. Your continued support has been exemplary, as you have also supported the pre-bargaining guidelines and sensitization. Further, we thank the IJM for the technical support on the decision to charge guidelines. We have worked with IJM on community dialogue and matters pertaining to police accountability and will continue doing so. We further thank the Space for Giants for the support in the development of the 9 prosecution points that are part of the decision to charge. We thank the criminal justice partners, the EACC, DCI, IPOA, and all our other stakeholders for having supported the process of the case management system and have shown interest in being integrated into the system. A hearty thank you to the Lawyers Without Borders for having been part of the development of the case management system, ensuring that all vital components required to develop the case management system were supplied adequately with the resources and equipment needed to make it a reality. A special thank you to the European Union for their support through PRID in the development of the decision to charge guidelines, as well as the support they have accorded our office. The EU supported the ODPP in its moving to the new headquarters on Nagati Road, particularly through donation of equipment and infrastructure. We thank the team that coordinated this event and the live streaming. Thank you to the service providers for ensuring a smooth event. We thank you to all the ODPP staff for their steadfast commitment towards efficient delivery. And now we can tell you that the work has just begun because we expect you to implement the guidelines fully. Further, we thank the DPP for being visionary and transformative in leadership, noting that in only 2 years, ODPP has truly been transformed. Lastly, we thank all Kenyans, those watching and even the others, for their great support for the office of the DPP in the fight against all forms of crime. God bless you all.
Thank you, Madam Emily. Ladies and gentlemen, we now wish to invite Madam Beatrice to put us in the hands of God, to be with us even during this difficult period, even as we have also partake of the snack. And please do not go before we plant the trees. We have a ceremony for the planting of trees for the guests. And also, remember also the invited guests, please remember to pass by and pick a package for yourself. And if you think you are okay, for your child, and if you don't have a child, then for your grandchild, and if you don't have one, for your neighbor's child. I thank you so much. I'm now redundant. I don't have a job. Beatrice, please, after this, please pray also for the snack, okay, and also for all of us. Thank you, and God bless you.
Shall we stand for a word of prayer? Let's pray. Heavenly Father, we thank you so much for this afternoon. We want to thank you for the way you've led and guided us throughout this event. We want to thank you for the guests who came here, the chief guest, the CS. We want to thank you for all the invited guests who came here. We want to thank you for the committee that spent sleepless nights to organize for this event. We want to thank you for the event organizer who have brought all this together and made it a success. Several people, Heavenly Father, have committed and contributed to this day. We want to thank you for each one of them. May you bless them. We want to thank you for the DPP, whom you've given this vision to even guide the process of development and now the launch of these documents that we've witnessed today and even the previous documents. We want to pray that you may help us as an office to put into good use these documents that have been launched to enable Kenyans access justice even faster. As we separate now, we want to pray that you go with each one of us and that you bless us. We want to thank you, Heavenly Father, for the snack that is ahead of us. May you bless it and bless us too. In Jesus' name I believe and pray.
Thank you. Thank you. But don't leave yet, because as I've told you, we have the DPP has seen of the chief guest. We have some assignment here on my right hand. We have trees to plant in commemoration of this event. And thereafter, we will have the snack and leave at our own pleasure.
The
Thank
Office
you.
of the Director of Public Prosecution,